Hey everybody, John Skiba here, and in this video, I'm going to share with you what happens if you have a personal guarantee on a business debt if you file for Chapter 7 bankruptcy. Also, if you are from the state of Arizona, wait until the very end because I have a very special statute that I'm going to provide you that can give you a lot of protection in the event that you have that type of debt and they're starting to pursue you for it. But first, if this is your first time here to my YouTube channel, go ahead and click subscribe, check off on that little bell. That way you'll be notified each and every week when I release a new video that can help you deal with your serious debt problem. All right, let's talk about personal guarantees on business loans. So if you own your own business, you're self-employed, you're doing your own thing out there, and you go and you get a line of credit, if you get some sort of credit card, something that's in the business name, hopefully you've set up like an LLC or you have some kind of corporation set up. But you will notice that almost every single time, a bank is going to require some sort of personal guarantee on that business debt. The reason why is pretty clear because otherwise the business could go out of business. And if they didn't have that personal guarantee, then they have no way of collect. So what they want to do is they want to have you personally on the hook as well. So this exposes not only your business assets, but your personal assets to any potential liability in the event that you default on that loan. So if you find yourself in that situation, if you're self-employed, a lot of people have been impacted here in 2020 with COVID. A lot of businesses have gone under. If you find yourself in that situation and you're having to file for bankruptcy, the good news is a personal Chapter 7 bankruptcy filing will eliminate your personal guarantee on that debt. Now, it's important that I be clear on this. It eliminates the personal guarantee. You will no longer have any personal liability. The creditor can no longer pursue you for your personal assets, but the business will still be able to be liable. Will still be liable for the underlying debt. So it's something if your business continues to operate, but you go through a personal Chapter 7, you're going to wipe out that personal guarantee, but the business is still liable. They could still sue the business, go after business assets, just not personal assets. Another question, just kind of as a side note that I get asked a lot of times, a lot of people will say, hey, I own my own business. It's shutting down. I want this thing done and out of my life. It's just, it's done. We're closing our doors. Should I file bankruptcy for the business? Now, while it's technically possible to file a Chapter 7 for like an LLC or a corporation that's going out of business, the real question is it really necessary? Because businesses, unlike individuals, do not receive discharge in a Chapter 7. So the whole point of a person filing a Chapter 7 bankruptcy is so they can get that discharge order from the court that says that they no longer owe these debts. Businesses do not get discharges in a Chapter 7 filing. Essentially, the only reason why you would do it is if there are assets that need to be distributed. If you were to file a Chapter 7, a bankruptcy trustee would step in, seize the assets, sell them, and make a distribution to your creditors. In nearly 20 years of filing bankruptcies, I believe I've done 2 Chapter 7s for corporations, and it was in that type of situation where there was a ton of corporate assets. They didn't want to store them anymore, and they just wanted to have them sold off by a trustee and paid out to the creditors. I once heard another attorney say, look, when you're closing a business, there's kind of 2 ways to do it. You can just shut the doors and end it, or you can hold a big, giant, fancy funeral for it. That's what a Chapter 7 is for a business. So it's usually not necessary. But if the business does shut down and you have personal guarantees, you can deal with that in a personal Chapter 7 bankruptcy filing and wipe out those debts. Okay, if you're still hanging with me on this, this is where I was going to bring up this thing that's very specific to Arizona. Arizona, where I practice law, is a community property state. That means generally that any assets that you get while you're married or any debts that you get while you're married are joint. There's some statutes here in Arizona that can protect you in the event that you have a personal guarantee and the creditor is starting to pursue you. Now, the specific credit statute that we're talking about is ARS, Arizona Revised Statute 25-214. This talks about the management and control of assets in a marital relationship, in a marital community. And basically what it says is that either party, either spouse can bind the marital community. You can go out, if I go out and buy a car on the way home and I don't tell my wife about it, I would never do that. But if I were to do that, my wife's on the hook. Even though she wasn't there, she didn't know about it because I bought a car. It's benefiting our marital community. We can both go out and do that. She could go out and buy a new car as well, or whatever debt it is. She could go get a new credit card, and I could still be on the hook for it because of the fact that we live in a community property state. However, Arizona law says that there are a few times when both spouses have to sign off on the debt in order for it to be collectible against the marital community. One of those times is in the situation where there's a personal guarantee. So if there's a personal guarantee, like on a business line of credit, and you're married, if both you and your spouse did not sign that personal guarantee, the creditor cannot collect against the marital community, meaning that most marital assets. Almost everybody that's been married for any amount of time in Arizona, most of their assets are community property. They're joint. It does mean, though, that they could still sue you individually, but they would only be able to collect against your separate assets. And like I said, most married couples don't have really much of any separate assets here in the state of Arizona. So that's one thing to look at. If you're being pursued in the state of Arizona by a collector or creditor on a personal guarantee, go back and look at the original documentation and see if both you and your spouse signed that. Because if they didn't, then you really cut their feet out from under them, and you may be able to do a really lowball settlement or even just get them to go away completely. So hopefully that helps when it comes to personal guarantees on business lines of credit. I know that can be something that can be really stressful. I've owned my own business for 20 years now, and I know that when you go out to get a line of credit, they always want you to sign on the line personally. If worst case scenario happens, though, you can eliminate those debts in a Chapter 7 bankruptcy. Thanks for watching today.